Good afternoon. I'm Carolyn Kaywood. I'm with the League of Women Voters of Southampton Roads, and I've been a participant on the Right to Vote study. We say here recommended program because this was adopted, the study, in the 2023 convention where it was approved by the delegation. The consensus process is used to discuss the study, and new positions can be formed that can be used for advocacy. We went back and forth a lot on what to call the right to vote and settled on inalienable, which has historic connotations, and also is defined as unable to be taken away from or given away by the possessor. We very much want to thank all the study participants, Arena Van Breda and Deb Wake from Fairfax, me, Chris DeRosa, Lisa Cotin-Gerchek, and Liz Scheffler from Arlington, Alexandria, Karen Siracusa, Linda Rice, Pat Black-Evers from Williamsburg, and Shirley Everett from Roanoke. They all worked very hard, participated in writing sections and helping refine and edit our final study document. The impetus behind this study was two constitutional amendments that have been proposed. One was on the right to vote, and the other was on enfranchising 16-year-old voters. The League of Women Voters was very much involved in establishing the United Nations, and for that reason, it sends observers to this very day. Eleanor Roosevelt, who was a prominent League of Women Voters member, chaired the United Nations Human Rights Committee. The League and the UN have a commitment to democracy and voting. In 1948, the United Nations Declaration of Human Rights states, whereas recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. And then in 2017, the United Nations Human Rights Office, in conjunction with the Carter Center, stated, democracy arises from people's desire for dignity, equality, justice, liberty, and participation, their desire for a voice. And as we often say, your voice is your vote. However, discrimination is a fact. As defined, it is the unjust or prejudicial treatment of different categories of people, especially on grounds of ethnicity, age, sex, or disability. You've heard in the past, they lack the capacity to understand voting. They will be unduly influenced by others in how they vote. The purity of the vote should not be sullied by them. These statements have been used to disenfranchise Black people, younger voters, women, and of course, those adjudicated mentally incompetent. The statements can be used interchangeably depending on who you want to discriminate against. It's othering language. We control what happens to these groups of people, and we come from a position of privilege and power. With the League's focus on diversity, equity, and inclusion, we feel it's important to look at voting through a DEI lens. Too often treated as a privilege, the League believes voting is a right. This study examines the history and underpinnings of the concept of a right to vote and how this is an inherent right belonging to those living in a democracy. In particular, it focuses on those disenfranchised in the Virginia Constitution, those under the age of 18, those with a felony conviction, and those who've been adjudicated mentally incompetent. And so we have these aspirational goals: protecting the right to vote, permitting 16 and 17-year-olds to vote in local and state elections, that those who commit a felony do not lose their right to vote, and they can vote in prison. Those who indicate a desire to vote should be allowed, even if they have a guardian. So we want to see a fundamental right to vote in our state constitution. We take guidance from the National League and, of course, never work in opposition to the positions we hold at the national level. So before we began, we reviewed the existing national and state positions. And you will see there on ending felony disenfranchisement. Now, one of the things we do as part of program, of course, is decide whether to retain our existing positions. And this is our current position. You'll note it's got some things that have long since passed away, like the property requirement. And it may seem archaic, but events have taught us you never know when something that seems settled in law will be overturned. So we keep all our positions. And I think it's important to note here also, we state that the treatment of all felons should be identical, regardless of the nature of their crime. In the past, some of the governors have parceled felons into different categories for restoration of rights. Our focus is on who can vote rather than the mechanics of voting, which has been covered by previous studies. Originally, only white landowning males aged 21 or older did all the voting. The Reconstruction Amendments abolished enslavement, provided equal protection, and extended voting to all men for a time. Though we know the Jim Crow laws erased enfranchisement for most men of color. Slowly, the right to vote has been expanded. The 19th Amendment expanded the franchise to women, but massive numbers of American women remained effectively disenfranchised because they were not white. The civil rights movement, and then the struggles for indigenous rights, Latino rights, and Asian American rights helped to make the 19th Amendment fundamentally true for most American women. States like Virginia, with a history of discrimination against Black voters, were placed under pre-clearance. That is, they needed to pre-clear election laws with the Department of Justice before they could go into effect. But then Shelby County versus Holder in 2013 removed many pre-clearance protections and allowed suppression tactics to go into effect across the United States, not just in the states bound by pre-clearance. And following that, Bronovich versus the DNC further restricted who could file a voter discrimination lawsuit. While the Constitution allows states to set the time and place of elections, it has been repeatedly amended to protect voters in various ways. We have a book about the League of Women Voters in Virginia by Bernice Colvard, Virginia Women and the Vote, which says, the League of Women Voters of Virginia was jubilant at the demise of the poll tax at long last. The League and others mounted massive voter registration drives, which frequently resulted in registrars being swamped. During this time, registrars could only register voters at their offices. They couldn't leave to do so. However, neighborhood registrars could be appointed to register voters from their homes, and the League actively participated as neighborhood registrars or assisted in identifying these auxiliary registrars. This led to huge increases in voter registration. You can order an updated version of the Virginia League history on the State League website. The Virginia Constitution, Article 2, Section 1, Qualification of Voters. Well, Virginia drafted a constitution in 1901, 1902, and supporting legislation with the acknowledged intent to disenfranchise Black voters, despite the 14th Amendment to the U.S. Constitution. The passage of the 24th Amendment and the 1965 Voting Rights Act compelled Virginia to rewrite its constitution, resulting in the 1971 Virginia Constitution, under which we currently operate. However, there were some things that did not get changed. Our study focused on the three groups specifically disenfranchised in this 1971 Constitution. 16-year-olds, actually 16 and 17, those with a felony conviction, and those adjudicated mentally incompetent. It was the life work of Yvonne Miller, who was a Virginia delegate from 1984 to 1988 and Virginia senator from 1988 to her death in 2012, to remove felony disenfranchisement in Virginia. Her mantle was taken up by Senator Mamie Locke, who has been working on this since 2004. We've been engaged in these efforts since 2019. But we're told by the League of Women Voters US that our principle of right to vote was not enough to support this advocacy and needed to be the result of program. And then recently, in 2023, Delegate Sam Russell introduced a constitutional amendment to lower the voting age in Virginia to 16, but without a position we could neither support nor oppose. Including those adjudicated mentally incompetent as voting eligible is often tied to the fight for voting rights for those with a felony conviction. So it made sense to include all three groups in our study. With the gutting of the Voting Rights Act by the Shelby County decision and the inability to pass the John Lewis Voting Rights Advancement Act at the federal level, the League of Women Voters of Virginia pushed for the passage of a state-level Voting Rights Act. It was first introduced in 2020 and again in 2021 when it passed. Now, this is the table of contents for the study. If you've ever worked on a study, you know that as you study, it shapes how you're going to report out because you don't necessarily know going in what you're going to discover. So this is an organization based on what we learned. And I would like to point out that only the first 36 pages are the study. We've got a huge section of resources and appendix of research on how various groups got the right to vote. So, I mean, I recommend reading the whole thing, but for the purposes of consensus, only about half of it is absolutely necessary. Well, 16 and 17-year-olds. Some of the reasons why we might want to give 16 and 17-year-olds the ability to vote in state and local elections. To cultivate the habit of voting. They would be learning about elections in a school and family setting while they're still at home. So it would be more supportive of them pursuing voting as a lifelong habit. They are fresh from their education about government and a democracy. In fact, maybe better informed than many older adults who've forgotten what they learned. And they have the capacity to understand the complexities of the issues. They want to be independent and see themselves as adults rather than children. Participation in voting fosters an understanding of the process, and it promotes critical thinking and a understanding of why this is all important in a democracy, and an opportunity to learn how voting has consequences. Considering the candidate platforms helps young voters refine their own values and priorities. Younger citizens are not necessarily being adequately represented by people who don't always remember what it was like, or calculate the long-term consequences of decisions being made now. For example, climate change, gun violence, healthcare, housing, education, and even debt accrual will affect today's young people for the rest of their lives. And I would add that many of them are getting a paycheck for the first time at the age of 16. And we have a foundational principle in our country that those who are taxed should have a voice in their representation. Virginia broadened its list of disenfranchising crimes to include things like loitering and being homeless or even being unemployed. It was a definite ploy. The 1971 Virginia Constitution does not mention restoration of voting rights, even though it was drafted to eliminate many of those Jim Crow laws put in place in 1901. Virginia disenfranchises all people with a felony conviction, even after they have completed their sentences and parole. Since 1970, the Virginia jail population has increased by 800%. Since 1983, the state's prison population has more than doubled. In 2019, Black people constituted 20% of Virginia residents and 53% of the people in Virginia prisons. In 2023, 12% of voting-age Black Virginians were disenfranchised, more than 1 in 10. Communities where Black people had been kept from the ballot box before the Voting Rights Act are the same communities where Black people are incarcerated at higher rates than after the Voting Rights Act. To circumvent the Reconstruction Amendments, many states enacted Jim Crow laws to effectively prohibit Black voters. Virginia's 1901 Constitution was open about that purpose. Felony disenfranchisement has been a ready-made tool for excluding Black voters ever since. Crimes that targeted Black people were added to the felony list. And felony disenfranchisement is still in our Constitution. This gives you a picture of the impact. Each column is how many people in a racial category, based on 100,000 of them in Virginia, are incarcerated. In prison, I should say. Not, this isn't just, it doesn't include jail. So the jail and prison populations have ballooned with a disproportionate number of Black people being incarcerated, which impacts Black communities outside prison walls. A JLARC study found that about 12,000 adult Virginians are disenfranchised, despite many of them having the capacity to understand the act of voting and a desire to vote, simply because a court has appointed a guardian for them. A person under guardianship should retain the right to vote unless an individual cannot accommodate, with or without reasonable accommodations, the desire to participate in the voting process. A court considering guardianship should apply a presumption that the right to vote is retained, a standard that does not exceed what's expected of other voters, and individually tailored accommodations consistent with equal protection and Americans with Disability Act requirements. The mental capacity standard should be the capacity to understand the act of voting and a desire to vote. Currently, many people who are placed under guardianship by courts also have their voting rights stripped without anybody even talking about it. I watched a man testify to the Disability Commission in August about the struggle he had to get his son's voting rights restored. You can listen to him if you like by going to the Disability Commission on the House Committee streaming service for August 15th. It's the last thing on the video. He really encapsulated the whole issue in 3 minutes. He said that when he hired a lawyer to help set his son up for a guardianship, he was told it was never mentioned. When he talked to the lawyer afterwards, he discovered his son lost the right to vote and was told that in Virginia, that's the default, which was never mentioned to him before. Only at the end of all the paperwork did he hit the phrase, shall not retain his qualification to vote. The lawyer asked him what argument they would use to say that his son needed guardianship but wanted to vote. He said his son was on the student council at school, he was in family discussions, and he had gone with his father to the polls. It took an additional $1,800 in attorney fees, court filings, and meetings with the judge to get his son's voting rights restored. The young man votes in every election and often reminds his father of upcoming elections. So in his testimony, the father stressed that voting rights should be included in every guardianship discussion. These are women participating in their first election. The League of Women Voters is committed to protecting every citizen's intrinsic right to vote. League positions are for the long term. If we believe in a principle, it doesn't matter whether today's political winds are unfavorable, we will go for the moonshot. The program process is educational, but also usually results in an updated position used for advocacy. Because resources like time and people are limited, studies are broad in scope, and so are the resulting positions. The results are aspirational and provide a platform for future advocacy. When we develop questions for consensus, they are yes and no questions. They should not lead to a particular answer. They do try to invoke thoughtful discussion and get past personal biases. They help us discover where we in the league have agreement and where we do not. The group discussion is vital. The consensus process is not voting. It's a sense of the group as a whole, though it does not have to be 100%. And I am not reading a quote by myself. This was a National Voter Registration Day event at Tallwood High School in Virginia Beach. They had a team of high school students there ready to help the league members who were staffing the table. And I just thought they were beyond cute. So, now what has it done that? The consensus questions that we want you to use to give the study group feedback. Democracy rises from the people's desire for dignity, equality, justice, liberty, and participation, their desire for a voice. If your vote is your voice, should everyone in a democracy have the right to vote? I'm just reading through the questions. The U.S. Constitution delegates to states the authority to decide who can vote, but amendments have expanded who can vote. Should the U.S. Constitution be amended to create one national standard for who can vote? Should the Virginia Constitution be changed to add a fundamental right to vote clause, both in the title and body of Section 1? Should the Virginia Constitution be changed to permit those who are 16 and older to vote in local and state elections? Should the Virginia Constitution be changed to remove the stipulations in Section 137, Article 2 of the Virginia Constitution that disenfranchises citizens convicted of a felony and those adjudicated mentally incompetent? Given concerns over aging and office holders and Supreme Court judges, should there be an upper age limit to vote? Should someone judged mentally incapacitated retain the right to vote if they demonstrate an understanding of the act of voting and a desire to cast a ballot?